we work with MSBA's attorneys to ensure that what we established with this association health plan is compliant, both from a federal and a state perspective.
Thank you. And you know, one of the reasons I'm excited to have you, well, a number of reasons. For folks who have seen me at maybe at the institutes, and I'm often sitting next to John at the in the tables, and I have to say one of the main concerns that we get from members is, how am I going to pay for health insurance? It is just it's a key topic. Health insurance is expensive. It is very difficult to run a business and pay for health insurance at the same time. It's expensive. So when we launched the association health plan, I was out of my mind excited, because that's an easy thing to sell to my membership, right? But of course, the rule is that when you do this, it doesn't work for the solo practitioners necessarily, because you have to have, and you can correct me on the qualifications here, but yeah, you need to have a W-2 employee. It can't be just you as a solo practitioner or as a solo business owner. So I remember when we started talking about this with members, I think we didn't maybe do a great job of saying why that was the case, and we got a lot of comments from folks saying, well, doesn't the Bar Association care about me? Well, sure, we care about you, but and the comment was, with all of the buying power that a bar association must have, why can't we negotiate a better deal for our members? And I think, like a lot of our members, I was sort of had the same place. I was at the same place. I didn't understand sort of how this worked. I thought, why, it's a business consideration of the insurance companies that we're failing to negotiate. It's not a legal network of, it's not a legal structure that we're dealing with here. So I think that's sort of what we're here to outline today with Jennifer's expertise on association health plans. So maybe let's just start there with what is an AHP? What are we talking about?
Yeah, it's a good place to start. And, I'll take you kind of through the history of how association health plans started way back when. I'll also take you through current day, and partially we'll talk about, what Mike had mentioned with this idea of why can't sole proprietors, or as used in current litigation, working owners, why can't they participate in the association health plan? And it really stems back to the definition of employer in ERISA. And ERISA was enacted in 1974. And there you go. Yeah, definition of employer is going to be a big piece of this. And in the actual law of ERISA, there's a definition of employer. And the reason, really the prime reason for the law of ERISA is to govern and really provide some rules and regulations around employer-sponsored retirement plans. That's where it really started. And then eventually we wrapped in the health and welfare side as well. And, as the law has evolved and as regulations have evolved, we have seen challenges to a variety of pieces of the association health plan kind of rules that are out there. But what really came to fruition recently with the current litigation is this definition of employer. The definition of employer basically is an employer that has employees, or a group or association of employers can come together to offer health insurance to their employees. And currently under the litigation, the memorandum that you're seeing here is from the lower court in the District of Columbia, the federal court, which basically said, along with 11 states in the District of Columbia, which argued that the final rules were an unreasonable expansion of the definition of employer, that it was just that you need to have that employment relationship. An employer can't be both the employer and the employee. So just to kind of take you back in time a little bit, association health plans are what we refer to and what you typically see in the actual text of the law is what's referred to as a multiple employer welfare arrangement, or MIWA. And MIWAs were highly regulated, or have been highly regulated, and are on the Department of Labor's enforcement agenda year after year. And the reason for that is because back in probably around the early to mid 80s, there were a lot of bad actors. There were a lot, and not necessarily association health plans, but just generally these multiple employer welfare arrangements, which are essentially employers that are unrelated can come together to offer coverage to the people that they're looking to cover, those employers are looking to cover. And there were a lot of bad actors, a lot of people that were not paying claims, plans that ended up becoming insolvent, and people were left with, you know, their health insurance claims that they were having to pay on their own. The insurance that they were paying for was no longer there. The money wasn't there because people were stealing it. So there's been a lot of guidance over the years around MIWAs. It's not just at a federal level. So it's typically, you know, when I work with a lot of clients outside of the association business, ERISA is all we look at because of ERISA preemption. But ERISA actually was amended, I believe, in the early 80s for these reasons of bad actors to allow the states to have a lot more say about health plans that we typically wouldn't see unless you were in a fully insured small group sort of situation. So the states, we have a federal level that we always look at, but we also have to look at the state level when we're determining, you know, what can we do with an association health plan.
So I had a quick question, maybe a clarification. When you were talking about the bad actors, and I'm trying to picture if it's, and to use the phrase bad actors on both sides, or are you talking bad actors in regards to the insurance companies were not actually following through it? Can you, I don't quite understand what you're talking about there.
Yeah, so when you bring together a multiple employer welfare arrangement and associations, you usually have a governing body that sits over, you know, trying to decide how the money flows. And there are some people that manage the health plans, not the insurance companies, but actually the managers of the health plans. So maybe trustees of the health plan or committee members that oversaw the actual payment of the claims. They were taking money.
So kind of somebody in the association. The association.
If we talk about the using an association as an example, and it wasn't always associations, you can have a multiple employer welfare arrangement that is unrelated to an association. You know, association health plans is what we talk about a lot, especially with all of you guys. And that's a little bit different. An AHP is a MIWA, but a MIWA isn't an AHP. The AHP, you have to take it to you've got a couple more things that you have to meet, some requirements that you have to meet in order to be considered an association health plan, a bona fide association health plan. And so whether it's trustees in the association or whether it's a trustees over a multiple employer welfare arrangement, most of the time these were trusts that were set up and money was flowing through that trust account and people were taking a little for themselves. And unfortunately, it left a lot of employers and more importantly, the participants unable to get their claims paid by those plans. So it was a highly regulated area. And as mentioned, the Department of Labor has had MIWAs on their enforcement list in their agenda for many, many years. And they do spend a lot of time digging in and making sure that things are on the up and up with regard to how the money is being handled. They want to make sure claims are going to get paid. So, you know, so I'm going to kind of back up for a bit because this does play a role in it. When the Affordable Care Act was first passed, you know, one of the things that they really were focused on, they focused on a lot of things, but they were focused on the small group market. They wanted to ensure that small employers and the group coverage that they were providing had certain provisions or requirements that really protected those small employers and the participants in those small employer plans. So there are things like essential health benefits that were required to be covered. There were very specific rating requirements. So they outlined exactly how every insurance company across the country in a small group, which is 2 to 50 generally, in some states it goes up to 100. But again, it starts at 2 because there's that employment relationship. That's what we talk about with ERISA and group health plans. But they were very specific on how you would underwrite that plan, how you would rate and provide rates to those employees in your plan. I talk about the ACA because it does come up again in current litigation. When the litigation occurred, it was as a result of President Trump issued an executive order, and then the Department of Labor issued, as a result of the executive order, final rules that expanded the access to association health plans. And in there, there was a lot of things that were happening within the regulation, but 2 main points that I wanted to make. One was the expansion. So actually, I'm going to back up a little bit to be what's referred to as a bona fide association health plan. So that you can be treated as a single large group plan. So you aren't subject to those small group rules that are in the ACA. You need to have a commonality of industry or trade. So for Minnesota State Bar Association, all the lawyers that are, and all the law firms and the folks that help support the lawyers in those firms are all part of the same legal industry. You have to have, the association needs to be established for purposes other than providing health insurance. Well, easily we can check that box because we're here for a reason other than providing health insurance today. And then it needs to be governed by the members. And so we know that there's not only a general committee that oversees kind of the MSBA, but we also have established a subcommittee that's specifically overseeing the day-to-day of the association health plan. So we've got those boxes checked for what's referred to as a bona fide association. And those sorts of bona fide association health plans have been around for a long time. I mean, since, probably the late 70s, we've seen some really longstanding association health plans under these rules. And then the rules that we got in 2018 expanded that. And they said, not only, you can go down this first pathway that we've had for years, but you can also go down another pathway, which is commonality of geography. So if you think about chambers of commerce, they don't have commonality of industry. You've got people from all different industries, but if you could do commonality of geography, then you could see chamber of commerce, those associations coming together and offering coverage for all of their small employers that belong to the chamber. And then the other piece that it expanded was to allow working owners or sole proprietors to participate in association health plans. So as you can imagine, the buzz around association health plans, because of that great expansion, geography aside, I mean, just to allow organizations like the Bar Association or CPAs or the dental, whoever might be a single employer or a sole proprietor could now participate in health plans. And that was really exciting. So you saw a lot of movement between 2018 and 2019 where chamber plans were being set up. You saw realtors. Realtors are typically kind of sole proprietors that work for an agency. Realtor association health plans are being set up across the country. And then Mike had up the opinion that it really started with these 11 state AGs, and the District of Columbia's AG filed suit and said this was an unreasonable expansion of the definition of employer. And the government said, well, we get the opportunity. This is what our role is to interpret the law. And they thought that, they argued that the definition of employer could be expanded to a sole proprietor. And so that was litigated. And the court unfortunately decided the definition was expanded beyond what the intent was of Congress, and it was an unreasonable expansion. So that was really one of the main focuses. There was other things too, but they also felt like these rules were a runaround of the ACA, because the ACA doesn't talk about a bona fide association. They don't talk about association health plans. They talk about employers, and they felt that small employers needed these protections from the ACA. And if you have this bona fide association, then these folks are not going to get those protections that the ACA says they need to have. And that's where it really kind of turns a little bit sideways for me, is because the association health plans that I've worked with and those that I'm trying to work with, they all are very rich plans. You know, that no one still has pre-existing condition exclusions. Everyone's covering essential health benefits. You know, these are fairly rich and robust plans. And so this idea that association health plans were going to be just these kind of crappy plans that don't provide the protections that small employers need was really, in my opinion, is really not true. So that all aside, you know, we still are stuck with this kind of decision by the court that says these rules are invalid. They can't be, we can't expand into the sole proprietor world. You can't expand into the commonality of industry or commonality of geography. And we're still kind of back to what we could have before. Thankfully, they didn't, these rules didn't impact that at all. So we can still have that bona fide association health plan under that first pathway, which is what MSBA was set up under. This was appealed, as you can imagine, by the Department of Labor. They appealed it. I know we're in the world of COVID, but this still shocks me that the oral arguments were held in the appellate court back in November of 2019, and we still do not have an opinion from the appellate court. So we expected it long ago, but we're still, you know, really sitting by and waiting to hear what the appellate court will say. The Department of Labor, they kind of gave into this. They didn't ask for a stay. They let the opinion ride and the conclusion ride. And they said, okay, for all of those that set up association health plans under this new pathway, this commonality of industry or commonality of geography, or, you know, allowing working owners, they were going to let them continue their health plans for the remainder of the year without any sort of enforcement. But then they needed to dismantle. And we've seen that. We've seen a lot of those chambers or small business kind of local small business associations that have had to dismantle, not only just from the geography perspective, but have also had to let their sole proprietors go back to the individual market. So
I was wondering about that actually, as a maybe totally inside baseball, but I kind of wondering, you know, how does Mercer attack these? When you see a final rule come through, are you assuming, you know, that's going to be litigated? We're not there yet.
We attacked it pretty quickly. As soon as it came out, you know, we thought, here we are, we've got an opportunity, but before we could even get really the wheels in motion too far, we started to see some of these rollbacks because of the opinion. So our intention at this point, we only set up association health plans that are under that original pathway. And we had a lot of conversations with organizations that wanted to do it under the geography or wanted to add their sole proprietors. And because association health plans, and, you know, we've talked about setting this up, but it took us about a year to set up this MSBA program. It was a long time. You've got a lot of things that you need to do behind the scenes to get it up and running. So by the time we got to ready to launch, these rules had already, the opinion had already come out to say we can't do sole proprietors. So we didn't even get to the point of getting those set up before we had to roll back and say, okay, sorry, we can't do this. So yeah,
it's just a natural part of the process. So so I mean, we're 2 years out or a year out from the district court opinion. Once the appellate, I almost hate to ask the next question, but if the appellate decision says that employer can include a sole proprietor, what happens after that?
That it can include?
Yeah.
I think we all celebrate. And then then we go and we talk to our groups, we talk to the MSBA, we talk to some of the other groups that then have the ability to expand their program. You know, assuming there could still be challenges, you could still see that this goes up to the Supreme Court. If that happens, you could see, you know, the state of New York and all all of the 11 states and District of Columbia, they could appeal it, and they very well may, especially given the switch in administration that will happen. They are trying to preserve the ACA. And so, we'll probably have conversations, but we'll also have conversations as to, we'll see what the Department of Labor says, how they will enforce or not enforce as a result. So we'll tread carefully. We will, and get legal minds involved from all sides and make sure that we're proceeding in the most appropriate way for the organization. Because the worst thing that could happen is to begin to offer the coverage and then have to roll it back again. I mean, just kind of that in and out is a little disruptive, as you can imagine. But yeah, we'll have those conversations and determine how we want to move forward.
I'll remind folks that they can chat in their questions into the Q&A or into chat. We'll make sure to forward those on to our presenters. Go ahead.
Go ahead, Mike. I was just wondering, because we talked a little bit about why the solo proprietors can't be in, and we all have to make peace with that for the moment, however we can. But can we talk a little bit about the benefits and where we're at with the actual program now, and who it is available for, and how to take advantage if we should?
Yeah, I think I'll probably kick it over to Ray and John, but I'm going to hit up Catherine just sent in. Catherine McKinnon sent a question. So can a firm participate if the owner or working owner and one employee participates? And the answer to that is yes. You need two. You need one, the working owner, and a W-2 employee. That can't be a spouse. That would allow you to participate in the association health plan. But Ray, I don't know if you want to talk about any additional, or I can talk about additional eligibility. So we know that the federal law says it needs to be, at least as I mentioned to Catherine's question, two people, the owner and one other W-2, but there could be an expansion of that. You can go all the way up to as many employees as you want. Typically we see, in the small group market, you see it up to 50 in Minnesota, but we can go above 50 if you have full-time employees that are above 50. So I don't know, Ray, if you want to add anything to that on eligibility.
Sure, yes. So the other requirements though now, and these are imposed now by the actual insurance carrier. It has nothing really specific to do with the actual the law. It's really more from an underwriting, from a risk-taking perspective. So specifically now talking with respect to the insurance carrier Medica, who's the sponsor for the insurance for AHP for MSBA, they do require them that there's, from a participation perspective, it's almost a two-pronged approach. 75% of the entire population, regardless of waivers, must participate. And of those, so it's at least 75% of the eligible employees that are not enrolled in another health plan would need to participate. And of those 75, a minimum 50% of the total number of eligibles need to participate. So there's a participation requirement. And then there's also a contribution requirement. So under, once again, the underwriting guidelines that Medica has set forth, they do require them, the employer, the law firm, contribute at least 50% of the employee-only premium, monthly premium, toward the overall monthly cost. So those are two primary additional requirements for eligibility to participate in the HP program.
And I see a follow-up question that is a great question. Kelly Sawyer asks, why can't the W-2 employee be a spouse if they're both attorneys? And this is just a regulation requirement. All of the sub-regulatory guidance that's out there under ERISA specifically says that it has to be a W-2 employee other than a spouse or any other dependent. So if you have a dependent child that was working with you, that wouldn't count as well. It's just the way that the law is established. And then Neil Meyer says, can the plan cover employees in another state? And Ray, correct me if I'm wrong, but employees can be in other states as long as the primary place of business is a Minnesota domiciled firm. Is that right?
That is correct. So that's another requirement. We require that the law firm itself be situs within the state of Minnesota. Employees can reside throughout the entire US though, but the law firm does need to be situs within the state of Minnesota.
Why does geography matter, either to underwriting or to the legal concerns?
I think that's an underwriting requirement for the carrier, right? Right.
Correct. That's Medica's interpretation of the regs. And so because of the fact that Medica is domiciled here in the state of Minnesota, their home territory is within the state. So they have declared that they will only want to write age-paid business that situs out of the state of Minnesota.
Interesting. Thanks, folks. Keep those questions rolling in. Stephanie.
But I do just want to clarify though, as long as the group is situs in the state of Minnesota, employees can reside anywhere and there is coverage. So there is network access, there's access to hospitals and doctors and physicians, urgent care centers throughout the entire state, throughout the entire country. But the only requirement is that the law firm must be situs in the state of Minnesota.
And the spouse rule, is that spouse or family member? I had it in my head that it applied to any family member, child, etc. Is it only spouse? Oh, you're.
It's a spouse or any dependent family member that is claimed as a dependent.
And then there was a request to repeat the second eligibility requirement before we get into the more complicated, how do we get it around these rules type questions.
I think the second requirement we're talking about was from a contribution perspective. So Medica, once again, their underwriting guidelines requires that the law firm contribute at least 50% of the employee-only monthly premium. And then, of course, the balance of the other 50% would be contributed by the employee. So they want the law firm itself to be able to contribute at least 50% of that employee-only monthly cost.
And then, of course, Brian asked the question that I think pretty much every lawyer out there ever does is, okay, so if the rules say this, what about that? And I think the hypothetical that he's putting forward is essentially, what if two solos end up hiring each other? Therefore, there's two W-2s. I'm assuming there's something out there, some comment? Any?
I love the creative juice that you have going at 8:30 in the morning. I don't know that I could argue against that. I mean, I think that there's probably some way to get that to work. Because if I think about how it all works from us getting a quote for these for the firms, they won't know that that individual might have, that's a second job for them. So it might be, it may work. I don't know, Ray. If that could, I mean, because you're technically then meeting the rules.
Right. And one thing to remember is that from a Medica underwriting perspective, it's just a question that they're going to ask on the actual employer application. So they will ask, is there an employer or employee relationship? Now, they do have a right at any given time to come and ask you, show us documentation, show us the W-2. But per what Brian's suggestion here, he is going to claim they have a W-2 employee. If you're going to issue out a W-2, that's documentation. So
then I think you of course run into all the domino effect of everything else that happens once you have another solo practitioner working for you, the law clerk. What about their cases? What about your cases? How do you update the state regarding your bar association? What about your licensing? What about, yeah. There's probably an overwhelming amount of additional things that you're going to have to do to pull that off. Yeah,
and in addition to just having being an employee, that idea of an employee comes a lot of employment taxes and filing all of that as well. So with the hypothetical that was put out, I mean, this has essentially
it's a two-person law firm with one of them being the employee. You had previously talked about needing two people, but in this situation, if just the employee is then getting the healthcare benefit, is that something that's authorized if it's not the employer that's getting the healthcare benefit, but just the W-2 employee?
All right, I'll kick that over to you. I think that the Medica allows that.
Correct, yeah. So yeah, that would meet the requirement, correct.
So if somebody out there has a paralegal or a law clerk or even another associate that they want to make sure is covered, even if the employer is not, this sounds like an opportunity for them.
Correct.
Yeah, this is an interesting space because you've got the legal requirements, but then you also have to look at what the carrier will allow. And those rules are very dependent on each specific carrier and what they'll permit. So you've got the first framework of the law, and then they always have their spin on it as well. So I think we have another question. I'm unmarried solo. An unmarried solo. By limiting my income, I qualify for paying plans for both men in the marketplace. Wow.
Yeah, so that's probably more information. I don't know if you want to restate that out to both the panelists and the participant or attendees, but we'll just put that out there. That sounds like there's multiple plans found on the ACA marketplace, so people should of course pay attention. This was from
absolutely.
a solo practitioner.
Yeah.
That's a good question. How, what does the market look like? How competitive is the plan?
So I guess I can take that. So obviously, Medica is sponsoring the program. Medica actually has their own small group program. They believe it's a huge initiative for them to be in the AHP business. They want to be as competitive as possible, but understand that they are taking the risk. This is a fully insured program. So they at the end of the day, they're going to underwrite appropriately via the actual risk that's presented to them. They believe that they can be very competitive. They actually have a history of other association health plans that have been very well participated with their membership. So we're very comfortable with Medica's position as being very competitive in the marketplace. But once again, it is driven by the actual individual risk factors that are presented, because at the end of the day, they are taking the overall risk of the program.
Looks like Catherine had another question as well. Oh, yeah, folks. So Catherine was wondering, how often does MSBA change carriers? In other words, are the standards that Medica has permanent?
So from obviously, the intent is to establish a long-term relationship with a given carrier. So we are looking at this from a long-term strategy that Medica would be in place. That's not to say that down the road, if MSBA, if the subcommittee, if the leadership decides that perhaps there needs to be competition, if there's some service-related issues, things of that nature, if there's an alternative choice that's a better choice, that we wouldn't vet those possibilities. But for the immediate term, it is to establish this a relationship with Medica, to build the relationship, to build the membership. By building the membership, then it also does make the offering competitive even more so.
Very cool. Folks, you're welcome to keep chiming in with the questions. I have a question about, I'm still thinking forward to the appellate decision. I think one of the things I don't fully understand about the case here is just the concern over the ACA. You mentioned that most of the plans already cover pre-existing conditions, but that's not really a legitimate piece. But what is the, so I guess there's essentially two questions. What are the policy concerns of these 11 states? What are the concerns that they have over this end run around the ACA? And is the second part of that question is the definition of employer essentially just a legal mechanism to say that it doesn't apply, or is there a substantive purpose to that definition of employer?
Yeah, so the first part with regard to the ACA, the Affordable Care Act set forth very prescriptive things that small group employers have to cover in their plans. And it's really about making sure that they have access to, robust coverage that isn't just bare bones and isn't covering some of the essential benefits, which is an actual legal term set forth in the ACA. That's a list of benefits that the creators, the drafters, they expected a plan to cover. There are plans out there that don't cover that. There are plans that are probably in the MIWA space or the association space that are not as robust as what, for example, MSBA has. MSBA is covering the essential health benefits. They are covering, or there's no pre-existing condition exclusion. Those things that were in place long before the ACA, those protections still reside. And at least in the plans that I've worked with and the plans that I've looked at, it's a pretty up and up. I mean, you guys want to offer your membership good benefits, robust benefits. You don't want to offer them benefits that, that are less than, what's kind of status quo. If you were a large employer and you went and worked for the Mercers of the world, you would have access to the same level of plans. And we really looked at that when we picked the plans that are being offered. We want to make sure that they're being offered, or you want your members to have plans that would be offered to if you were working in a large employer. So, there were and there are plans out there that didn't meet those requirements. And because you're in the large group, because again, if you're a bona fide association, you can kind of get out of the small group world and be treated as a large group. Large employers aren't subject to the same rules that sit in the small group. So large employers don't have to offer essential health benefits, but if they do, then there are rules that apply there. But again, most of the large employers are offering essential health benefits. Now, there are large employers that don't, that is not one of their core principles, is to offer robust programs to their employees. And we've seen them out there in the universe. So I think that was the big thing, getting out of that small group, and which is what association health plans truly are. They're usually small groups that come together. So they were afraid that, and I'm really talking long here, they are afraid that by taking them out of those protective places under the ACA and putting them in this large group, all of those protections are going to go away because large group aren't subject to it. So that was a long way to answer your question.
No, that's super helpful. It's true. I just reading the opinion, it's hard to put my head around like, well, what's actually going on here? It seems like a good idea. There must be some background here that I'm assuming that because the issue here is whether or not the definition of employer from ERISA applies. Well, that seems not like obviously that's not why we're bringing the case. But that's what leads to my second question is there something just substantively that I'm not understanding there about what it means to be an employer?
So there has been a long history of sub-regulatory guidance, case law that establishes what exactly is an employer under ERISA. And if you go back to the initial intent of ERISA, it's really to govern and provide rules and regulations for employer-sponsored health plans. So this opinion, and of course the 11 states and DC have determined that, when you look at all of that history, how could you get to another result? How could you come to the conclusion? And that's an unreasonable conclusion based on this history and based on the initial intent of what ERISA was enacted for, was to govern this employment relationship. And there hasn't been since 1974, we haven't seen any challenges like this that would allow the expansion of ERISA to cover individuals. That's just not, I mean, whether it's on the retirement side or on the healthcare side, this is the first attempt that I'm aware of. And maybe there's case law out there that I am not aware of, or attempts to do this previously, but you know, this is a fundamental piece of ERISA in their mind. And though the Department of Labor has the opportunity to expand it or interpret it, excuse me, they found this to be an unreasonable expansion and unreasonable interpretation of that definition. So here we are.
Yeah. Okay.
It,
when that decision, when that comes out, and let's ask the crystal ball question. What's your anticipation?
I don't know when it's going to come out. You know, it's interesting. Looking at the oral arguments of the appellate court, it was actually quite interesting. They didn't focus on the working owners piece as much as I would have expected them to. This whole piece that really hinges on whether or not we can offer coverage to sole proprietors was not the key. They really focused on the small group piece and the ACA, which was interesting to me because I think it should be reversed, but that's just my own personal opinion. I think this idea of whether or not ERISA can be expanded for the purposes of allowing coverage to sole proprietors in an affordable, or I'm sorry, an AHP environment, I thought that would be kind of the hit, because you can see if you read this opinion, there's a big focus of that in the lower court. But the appellate court, the oral arguments, and maybe they had already made their decision and they didn't want to dive into that further, but you know, there was just kind of a lack of questioning to both sides as to, you know, this idea and this expansion. You know, if my crystal ball, unfortunately, I don't necessarily think they'll, because of the court that we're in, we're likely to see this upheld. What I keep pondering next is, you know, we expected that if it is upheld and continue to be deemed invalid, then I would have expected it to be appealed by the Department of Labor to the Supreme Court. But we are now in a situation where we're going to have a very different administration. So I don't know that the Department of Labor is going to take it to the Supreme Court with the new administration, which will be interesting to see if they're standing by someone else to be able to continue to take this forward. So yeah, we're waiting. We don't know when we're going to get it. You know, I would have expected it long ago, but COVID has really thrown a curveball to all things, as you all know. So I'm surprised because the oral arguments were held long before COVID began. I guess maybe I shouldn't say long before, but before we were all in shutdown. So it seems unusual that it's taken this long, but.
But you provide a lot of great materials, and I'll make sure that when we share this in the practice law library that I provide links or just the documents. This opinion, I should have brought up I assume it's in the DC Circuit Court of Appeals. I'll bring up that docket number for you, and we'll drop those into the course materials and put those in the practice law library as well. You mentioned this, boy, did I save that article? Let's see.
And Mike, we had a request for the event code. I want to make sure we get that out there.
I wish to get that at the bottom of the article. Yes, we do. Let me type it in here. The event code is 339590. That is 339590. Thanks for the reminder, Naomi. I appreciate it. For folks who are part of this program regularly, they know that I never remember that until I am reminded. So I appreciate that. Joan had an interesting comment as well, dealing with mental health. She says, unfortunately, Medica has been one of the most restrictive in covering mental health and substance use care. Lawyers Concern for Lawyers has information about options for covering mental health and substance use treatment expenses. That's great, Joan. Yeah, if you want to forward those to me, I'll be sure to dump those into the program page as well. That'd be great to have those. What about that? Joan says, great service of the MSBA, but where are we at with the providing of mental health services?
Well, I can start just from a legal perspective. There's a requirement to offer coverage, and the Mental Health Parity Act is expanded, and it was really it was a focus of mine before I switched into the association health plan side. There's a lot more, and it's even as recently as earlier in 2020, some additional guidance for employers as well as health insurance companies to cover and be very thoughtful about how they cover mental health and substance abuse treatment. So I think that things are evolving in that space. I can't speak to Medica specifically, so I'll ask Ray to kind of play into that or to comment on that. But things in this space from a legal perspective continue to evolve and grow, and I think the carriers are sometimes slow to react. Because there's so many operational things that they have to do to kind of adjust to the legal side of things. But I know that those rules and regulations have put a lot of pressure to make some significant changes to what carriers across the country, not just Medica, but really change the outlook of what they're covering, how they're covering it, how they're reviewing cases and claims, and hopefully that will show itself here soon. But I don't know, Ray, if you have any general experience about what Medica covers or how they view these benefits.
Yeah, no, it's a great question, and you're spot on. I think Medica has been slow with respect to mental health, but now, given the law that it is a law, the mental health parity law, they will hit the standards. But they are, because of the fact that it's not a matter of are they committed to doing it. It's a matter of from a operational, from a technology perspective, infrastructure perspective. So they are building a lot of infrastructure in order to ensure that they are at parity with mental health and with all other benefits. But it is ever evolving, and it's a valid criticism, absolutely.
Just to make sure if I got the correct reference here on the Mental Health Parity Act, is this the resource that should be?
Yes.
Okay.
And that's a good start.
Okay, yeah. Great. We have a lawyer audience after all. Make sure.
Yeah, I get it.
Great.
I should note, and I know, Mike, I shared this with you earlier, as we're looking at government websites, and this is a great government website for the mental health side. On the association health plan side, the Department of Labor and EBSA is the kind of subcommittee or subgroup within, or sub-agency, I guess I should call it, within the Department of Labor that really puts out all the information with regard to association health plans. And I gave Mike that link, and I said, but we should be a little bit cautious. And I just want to share this because I'm all like you. When I hear things, I want to go and look at it myself, and I want to read things and kind of try to put it all together myself and try to understand it, because you're only hearing it from my view, which is sometimes not as crisp and clean as it needs to be at 8 o'clock in the morning. But the Department of Labor, if you go to the association health plan section, which I think the department in HHS or whomever it might be, they usually have a really wonderful kind of outline. It's a good resource to understand what's going on. But the Department of Labor, if you go to their front page on association health plans, you scroll down, there's some FAQs, you see some compliance assistance publication. It's going to tell you that working owners can participate in association health plans. So I was a little cautious because I thought, well, that's not the case. But if you go into that policy statement or the FAQs regarding association health plans, it got buried in there where they talk about how, this litigation has impacted the final rules and has set forth, kind of what they're doing or what their enforcement will look like in regard to this litigation. So if you just do at first glance, it looks like John Cordes doesn't know anything. She doesn't know what she's talking about. But truthfully, you got to dig in. It's not as transparent as you might hope it would be. So just know that you got to dig further in order to kind of get to where we're at today.
I appreciate you mentioning that. I'll make sure that when I drop that into the production page, that it's got the caveat listed there. I wasn't quite sure what the concern was, but you have a great note here. I'll include that in the material, so we're not relying on this unnecessarily. So read the fine print, folks.
That's right. That's right.
I think most of these government websites, I'm just so impressed with actually the federal government websites especially seem to be really provided the link to the Federal Register. This is an amazing resource. I think it's easy to read and use.
Yeah.
I really like federalregister.gov for what it is. It's a good resource. I'm gonna throw out a last pitch for questions. Now's your chance, folks. Let us know if you've got additional questions for our panel. Otherwise, as closing thoughts, maybe we can have Jennifer, John, and Ray throw in your contact information in the chat for folks. So if they need to follow up with you, they can do that. However you want to be reached by them. And again, we'll have more of this information this afternoon up on the presentation page. Hope everyone found this as much fun. This is just a crazy area of the law. I mean, it is my colleagues in law school who came in as artists and ended up as tax attorneys always interested me because they're like, oh, it's just this puzzle. It's you've got your fingers in 5 different sections of you've got all the Post-it notes out in the printed text. That's
oh yeah, that's so true. And the acronyms, I remember as a newbie, and I would sit in the office of our partners, and I would have on kind of the side of my pad of paper, because when people used to use pads of paper, I still do. I would have all these acronyms, and I would walk back to my office and I would Google what in the world is a quadro, or what is a QMSCO?
QRO. Yeah.
Yeah. And then, then you get along the way.
Well, that's the thing too. People can refer to it as a quadro, and you're gonna Google QUARDO unless
right.
unless you have seen it in print.
Right. So it is a unique area of law that is a lot of complexity, and it continues to grow, especially with association health plans, and specifically, we've got the federal law that we look at, but then you have to look at the state law, and thankfully Minnesota is actually pretty friendly towards association health plans, which is not the case for a lot of other states. So your friends in California, we're not going to do an association health plan in California because it's impermissible. So, I mean, not technically impermissible, but there's a lot of things that go with it, but we just can't do it. It's not feasible there. So, it's state law also rules kind of the world that we live in. But again, thankfully, Minnesota is friendly and allows us to do this plan, offer this plan to all of your members.
Well, thanks everyone for joining us so early in the morning. I really appreciate this high level, deep look into this area of law. It's so early in the morning. Yes, Kelly, thank you for joining us. Thanks everyone for joining us. Have a great rest of your day.